Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be California Landlords. Your late fee provision could be illegal. Hello, hello. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. If you were listening live, the name of the song was It's Too Late by Carole King. It was released in 1971. Now, while Carole King wrote the song, the actual lyrics were written by Toni Stern, who was her close friend and collaborator. And both of these women had just broken up with their significant others. Carole had broken up with her songwriter husband, Jerry Goffin, and then moved from New York to Los Angeles to a street called Laurel Canyon. And Toni had just broken up with an incredible songwriter by the name of James Taylor. Now, the lyrics reflect a quiet adult understanding that a relationship has ended, not with rage or betrayal, but with sadness and acceptance. And the reason why I picked that song, It's Too Late, well, that's because of my opening topic, which is California landlords, your late fee provision could be illegal. Okay, let's talk about the show format. As you know, we have an opening topic, and then after that, I will open it up for questions and answers for those participants in the Zoom meeting room. If you do want to talk to me, it's so simple. Electronically raise your hand. You'll see it on the toolbar on the bottom, or if it's not there, look in a folder called Reactions. If you're watching this on YouTube, I appreciate that. If you think you could benefit from learning a little bit about landlord-tenant law and how to manage your income property, then I would ask kindly if you could hit that like button and subscribe to my channel, because it does really help. If you do want to join the Zoom meeting every Saturday at 3 p.m., that's pretty simple. Just go to my website, which is evict123.com. That's EVICT123.com. You'll see the credentials on joining the Zoom meeting. Okay, let's talk about the opening topic. California landlords, your late fee provision could be illegal. Landlords are entitled to have their rent paid on time, and therefore late charges can be enforced. Now, late charges cannot be charged unless there is a specific provision in your lease agreement that existed from the inception of the tenancy. And therefore, in most instances, you can't do a change of terms of tenancy to now add in a late charge provision once that tenancy has started. In addition, there has to be specific language in your rental agreement to make late charges legal. Late charges cannot be a penalty, and they can't be considered punitive. Late charges must be treated as something called liquidated damages, and that's under Civil Code Section 1671, subsection D. I'm going to share my screen with you because I have it written as to what does liquidated damages mean. And there is my screen on that. So what are liquidated damages? Well, let's read the definition. Liquidated damages are a predetermined amount of money that parties to a contract agree to in advance as compensation for a breach of contract. The amount is specified in the contract itself and is intended to be a reasonable estimate of the actual damages which would be incurred if a breach occurs. Now, what the hell did I just say? You guys don't know what I just said. So let me try to explain it to you. If you have a provision in your rental agreement like a late charge, and if the tenant doesn't pay his rent on time, what is the cost to a landlord if a tenant doesn't pay his rent on time? Maybe he pays it 10 days late, maybe 5 days late, maybe 20 days late. What is the expense to the landlord? Well, see, that's really kind of a difficult amount to determine. Of course, you might have to now keep chasing the tenant and going over to his apartment and demanding the rent. and you've probably already deposited the other rent checks. So what that means is now you're going to have to make a separate second trip to the bank to deposit the new check that you just got. So this is basically where it's difficult to ascertain what it really cost you, but it did cost you something. So as it goes on here, a late fee for rent shall be considered a form of liquidated damages if it is a reasonable pre-estimate of the costs incurred by the landlord due to late payment. Like I said, administrative costs, lost interest, etc. Okay, there was a case that came down in addition to that code section, which was called Orozco versus Casimiro, and that quantified that phrase must be contained in the rental agreement. Now, you can't make it where it's an unreasonable amount, like $20 a day. No one's going to buy that. That will not be considered liquidated damages. And it can't be where it's a penalty. Like if you don't pay your rent late, then it's a $50 charge for payment. Or you could make it where it's a 6% charge. You can't have that. You have to have specific language in your rental agreement that shows the world that this is not a penalty, it's not punitive, and therefore it's considered a liquidated damages because it's difficult to maintain. I'm going to share my screen again, and I'm going to direct you to my rental agreement, which is on my website, evict123.com. It is absolutely free. And if you go to paragraph 12 of that rental agreement, you're going to see this phrase, and I'm going to read this to you. Now you're kind of sinking in what liquidated damages mean and why it has to be liquidated damages. Otherwise, it's not a legal late charge. So let's read. The parties agree that it would be impractical or extremely difficult to fix the actual damage incurred by the landlord if the tenant fails to pay the rent timely. An administrative cost, which is related to collecting and accounting for the late payments, will be assessed at an additional sum of $50 if rent is not paid within the 3 days of the due date. The parties further agree that the acceptance of this provision will be considered evidence in any legal proceeding that calculating actual damage would be impractical and extremely difficult to fix. So based on that, we've now, having this phrase in our rental agreement, we've now complied with the law that we're stating that this is not a penalty, it's not a punitive amount, it's a flat fee of $50. You could make it less or maybe a little bit more, but I would stick with that. Now, the reason why you can't say, okay, if the rent is not paid within 3 days and you have all this same language, but then you write, then the late charge will be 6% of the rent. That's not going to hold water either, because you see, what's your administrative costs? How are they different if it's 6% of $5,000 per month rent versus $1,000 per month rent? You still got to chase for your money. You still got administrative costs. You still got to go to the bank twice. So if you just say 6% of the rent, that's not going to work with regard to the requirement of having it as liquid damages. So on that basis, make it a figure. And mine, I don't give my clients a choice if you use my rental agreement, though I guess you could wipe it out, but we do make it as $50. Okay, let's move on to, let's see here. What are the eviction pitfalls, okay, with regard to a late charge? And this is some really serious stuff. You cannot include a late charge in a 3-day notice to pay rent or quit. You cannot. If you do, your notice is totally defective. That's why they call it a notice to pay rent or quit. They don't call it a notice to pay rent and late charges. They call it a notice to pay rent or quit. So do not include any late charges ever in a notice to pay rent or quit. And the next thing that landlords do, thinking that they're being very clever, let's pretend that the rent is $1,000 per month and there's a $50 late fee incurred if the rent is not paid within 3 days of the due date. So the tenant on the seventh day will give you a check for $1,000, a proper, legitimate check. So some landlords love to do this, and that is they take that 1,000, they apply $50 towards the late fee, and then they apply $950 towards the rent, meaning that the rent is going to be delinquent in by $50. That, again, is not permitted under the law. Under the law, it is the debtor slash tenant who determines what he's paying for. It is not the landlord slash creditor. So in that situation, you can't say that the rent is delinquent by $50 because you applied the first $50 to the late charge. Now, if the tenant says, I'm paying, this is $50 for the late charge and the balance for the rent, and he puts that into the rental agreement, well, then that's fine. But that's not going to happen. Okay. So whatever the debtor slash tenant determines what he's paying, and in this case, he's paying for the full rent. So in that case, if he still owes you the $50, then I'm going to ask you, how do you determine, how do you get your $50? How did you ever enforce that late charge provision? Can you take it from the security deposit when the tenant leaves? And the answer is no. And the reason for that is that from a security deposit, you can only deduct for rent, damages to the unit, and reasonable cleaning. Well, late charge is not rent. So on that basis, because otherwise it could go into a notice to pay rent or quit. So on that basis, you can't take it from the security deposit. So how do you enforce that provision to obtain your late charge? Well, let's share the screen again. And what you're going to see here, ladies and gentlemen, is a notice to perform conditions and covenants or quit. That's the form you can use to enforce your late charge provision. Let's see if I can make it slightly bigger. So this form is on my website in our free form section at evict123.com. EVICT123.com. And you can see what I filled out. You put the tenant's name there, Mr. Late Tenant. And then I have his address in this spot here. I have the date that the notice was prepared and the date that the notice was served. That could be different. And then here, the form says terms of the violation. So I have written in, pursuant to paragraph 12 of your lease agreement, a $50 late charge is incurred if rent is not paid within the 3 days of the due date. So in a notice to perform or quit, you have to tell the tenant, what paragraph are you talking about in my rental agreement? Then you have to go on to state what he did improperly. So as I continue to read, you paid your rent on November 7th, thereby incurring this late charge. And then you have to tell him what he needs to do to fix the problem. And that is within the 3 days of the service of the notice, you must pay your landlord the sum of $50. Got to pay the $50 within the 3 days stated herein. These notices require that you write good landlord and the date and time. So you could fill this out. So in a lot of cases where you have a Section 8 tenant, it's impossible to evict the tenant for non-payment of rent. Now, why is that, you might ask? Well, I'm going to stop sharing here. And that is because under Section 8, as you probably know, there is the major portion of the rent is paid by Section 8. A small portion of the rent is paid by the tenant, and that's what's not being paid. Well, generally, and we'll use an example, that if the rent's $2,200, the Section 8 is going to pay $2,000, and the tenant's going to pay $200. But what if he stops paying the rent? Can I serve a 3-day notice? Well, in municipalities like Los Angeles City and unincorporated areas of LA County, they have something called the threshold, the fair market value. And once again, I'm going to share my screen. So in the city of Los Angeles and unincorporated areas of LA County, if I have a 1-bedroom apartment that's going for $2,200, of which $200 is paid by the tenant and $2,000 is paid by the landlord, by Section 8, then how am I going to be able to serve a 3-day notice on the tenant? If he doesn't pay for the month of November, he owes 200. But as we can see from this chart, you can't serve a 3-day notice in the city of Los Angeles or unincorporated areas of LA County unless the notice exceeds $2,081. Well, then how am I ever going to get this? Because in month 2, it's going to be $400, month 3, $600. Literally, you're going to have to wait for 11 months when the amount is owed is $2,200. Now you're going to be above the threshold. Well, this is just garbage that the city of Los Angeles and the county supervisors did. Let's see if I can stop sharing my screen here. Thank you. That in instituting this fair market value specifically for Section 8 tenants, because you can never serve a 3-day notice. You're going to wait 11 months. Well, there is a way around that, and that is serve a notice if you have a proper late charge provision that mimics liquidated damages as required by the code. You could serve a 3-day notice to perform or quit for the $50. If that tenant doesn't pay you the $50 within 3 days, you can bring forth the lawsuit. But you might be saying, but what about the fair market value requirement? You don't have to worry about that. That's only for rent, and a late charge isn't rent. So you have the right to serve this notice and proceed forward with an eviction, which is about the only thing you can do and what we have been doing. And I know what's going through your mind. You're probably thinking to yourself, is a judge going to throw out a tenant who didn't pay $50? And the answer is yes. We take this case to court all the time. We show how the tenant's never going to pay these fees, and that the only way we can enforce our rights is by going forward with an unlawful detainer. And that, my friends, constitutes our opening topic, which is California landlords. Your late fee provision could be illegal. Very simple way to solve that. Use my rental agreement. Let's open it up to now questions and answers. And we know the rules that this program is for informational purposes only and is not a substitute for legal advice. If you do want to talk to me, once again, hit that raise your hand button on the bottom there, and I'll call on you in the order that you did raise your hand. Remember, this broadcast is for general questions only. If you do have a case with my office, please call me on Monday. I'm happy to answer those questions for you, but we only talk about general questions. And also, if you are talking to me, leave your camera on, because it's really enjoyable if both of us and the rest of the audience can see this. And you guys who are watching on YouTube, again, if you could please hit that like button and subscribe to the channel. If you want to ask me a question, you can leave it in the comments, and we're happy to answer that as the week goes by. And in case anybody doesn't know, my firm will answer questions for landlords, whether you're a client or not. All you got to do is call my office, and like from 9 to 4 o'clock, Monday through Friday. We're actually even open on Saturday, where I was today, from 9 to about 11:30. And just call our number, which is 1-800-77-EVICT. That's EVICT. We're now going to open it up to callers. And I think everybody knows this first caller. This guy's name is Jim Polina. How are you, sir?
There we go. Hi, Dennis.
Are you swimming again?
What's that?
You swimming again?
I'm a creature of habit. Okay, I got a curious question here. I heard your topic, I get it. But in your lease, don't you state that all monies owed to landlord is considered rent? And then you just got done saying that late charges are not rent.
Correct. And I have debated whether to take that phrase out of my rental agreement in terms of serving a notice to perform or quit. But of course, the provision in the rental agreement, which makes it a legal late charge, is still there.
Got it. Got it. Okay. Second question. There's another attorney in town. He's a pro-tenant attorney, Stephen Carlson, or I think that's his name, Carlson. And he says that these late fees are easily calculated by the lost use of the money, of the rent, at 10% per year divided by all the days that rent is not paid, which could be like 5 days, 7 days. So
Well,
the damage is like $1.50.
Steve Carlson is a male number one. We've come across him many, many times in my career, which spans, believe it or not, 50 years. The courts have upheld liquidated damages. I don't agree with his position that it's just, quote, the interest. I mean, if you have to sit there and go to the property 4 or 5 times to collect your rent, there's a certain cost to that. If you've got to now make double entries into your accounting software, if you've got to now go to the bank to cash that check multiple times because you're having different tenants pay at different times. I think that is a cost that's difficult to determine, but certainly is not $1.50. Anyway, thank you very much, Jim. We are going to move on to Suzette. How are you?
Hi, Dennis. How are you?
I am fine, thank you.
Okay, I'm at work today, but I haven't left yet. I wanted to wait my turn. So my question is, I had a mold company go into my tenant's unit yesterday, and today they told me that they found mold due to water leakage, but I have to wait for a report for them to tell me what abatement needs to be done. My question is, since the mold is present, they just didn't give me the thorough report. Do I have to pay for my tenant to leave the unit while we wait for this report and then conduct the abatement?
I don't think you need to wait. I don't know how long it's going to take for your mold company to determine what requirements are necessary. Even if their mold company is telling them to get out, I don't think that that's your position or responsibility to pay for that. You didn't mention what city is this?
This is LA City, the city
Okay,
of
yeah,
LA.
there's no provision under the law for that if the tenant has to be temporarily out for a short period of time, that you have to pay for their expenses. I know
Okay.
that in my rental agreement, I state that you have to have, the tenant has to carry a renter's insurance, which
Mhm.
includes reimbursement by the insurance company if you have to relocate temporarily. So if you have that provision in your lease, you certainly wouldn't be responsible for that. But a lot of landlords, just for the ease of it, will say, okay, I'll put you up in a hotel for 2 days. And that might just be a regular business decision that you might want to make.
So can I just tell him he needs to leave though? Because there's mold
Well,
there.
is it at a level where it's deleterious to his health?
Well, they didn't say that. They didn't
Okay.
say that. They just said
So
it was
how
mold
long
was
is it going to
present.
take to get the report back?
Well, because they just did it Friday, today's Saturday, they said 3 working days. So I won't have it until next week, Monday at the earliest, I guess
Well,
Wednesday at the latest.
you might want to disclose to the tenant at that point and let the tenant make his own decision.
Sounds good. Thank you, Dennis.
All right, Suzette, nice talking with you. Moving on to Dean, how are you?
I'm doing well, thank you. So I have a question. I have a fourplex in Montebello. I'm a new owner as of June of this year. Um, I was talking to one of the tenants, and she said she's been there since 2017, and she said that the paint is looks terrible, and there's a hole in the wall, and she would like it the place painted. So she's been there 8 years, and I said, well, what did it look like when you moved in? And she kind of copped to that it was painted. It looked good. So whose responsibility is it to pay for painting a unit after, say, 8 years that the tenant's been in there?
If the painting is peeling or chipping, it is the landlord's responsibility, regular maintenance, to take care of those issues. So if you see it peeling or chipping like that, then I would definitely go in there and take care of it. I mean, I don't know how long paint lasts, but 8 years seems like a long time.
Okay, and what I said to her, I didn't want to just roll over and say, oh, sure, I'll just give you, or pay whatever. I told her I wanted to see it. So I said, I'll come over on Sunday. And she said, oh, I'm not, I might be working on Sunday. So that's where we've left it. But I said I wanted to see it So I
Well,
could
I would.
determine is it peeling or is it dirty, you know?
Exactly. So what I would do is I would serve an access notice. You can get that form on my website in the free form section and go into a regular business day, Monday through Friday, say you're going to check to see the condition of the paint. And I would do that.
Go in there whether she's there or not.
Yep.
Okay, thank you.
And thank you. Tony, how are you today?
I'm good. Yourself, Dennis?
I am fine, thank you.
Hey, Dennis, I had a quick question. For RSO property, if I've inherited a tenant without a lease, how would some basic rules and regulation be determined?
Well, obviously the tenant can't break any laws. You know, he can't be shooting up the place. He can't be creating a nuisance on the property. But without a rental agreement, he can bring in extra people. He can bring in a dog. He's obviously got to pay his rent on time because that's part of the oral rental agreement. Unfortunately, under the crazy laws that we live in, you can't force a tenant to sign any kind of a rental agreement.
Right. Right. So basically, in terms of them bringing additional tenants into the property, they can actually do that.
They cannot. However, under LA rent control rules, you are entitled to a 10% rent increase if in fact they bring in an additional person, but you have to serve that rent increase within 60 days of that extra person moving in.
Right. Okay. And basically, there's nothing to do to withhold additional tenants from entering the property, huh?
No, now you might want to tell the tenant that, you know, if you're willing to sign a rental agreement, I'll forego this year's rent increase.
Mhm.
So I would like to have a rental agreement on file. That might be an incentive to that tenant to sign a rental agreement.
Gotcha. Second question, Dennis. I do need some consultation in regards to a lease that I have. How would I be able to get in contact with you or a associate of your office?
Just call the office, 1-800-77-EVICT, and you can set up a consultation. And usually I'm the guy who does the consultations at the office.
Okay, gotcha. I'll give you a call Monday.
All right, sounds good.
I think.
Thank you. And we're moving on to Roman. How are you?
Hi, Dennis.
Hello.
Hello, can you hear me?
Perfectly.
Yeah. Hi, Dennis. I have a question to follow up your topic. I have a rental agreement that's been in existence for a number of years, 20 some years, and provision of late charges stipulates 6% penalty, 6% charge if rent is not being paid within 3 days. I understand that it's illegal now. How can I modify a rental agreement to include your language in the agreement?
And I think I started off at the start of the broadcast that you can't do a change of terms of tenancy. I presume this is a rent controlled area?
Yes, yes.
Yeah, you're not allowed to do that at this point. You want whatever rental agreement they moved in is the rental agreement that you have, and you can't do a change of terms of tenancy to make it now a legal late charge when prior it was not.
So is it 6%, I understand, is not enforceable? Is it correct?
I don't think it's enforceable, but I mean, if the tenant pays you, he pays you, but I certainly wouldn't be bringing forth any eviction based on that.
Okay, and I have a second question. I have tenants who purchase oversized vehicle, huge truck that they park in the parking space designed for the regular size cars. And these trucks they use for the business, gardening business, and they store tools and equipment behind the truck. And I asked them to move the truck because truck protrudes from the parking space outside about 2.5, 3 feet and impedes on other tenants' parking access.
I think I got what the issue is, Roman. You want to check your rental agreement. I know if you use my rental agreement, if it gives you a space, it says for the parking of a passenger automobile only. So this would not be a passenger automobile. This is something for work. Also, you want to check your rental agreement to see if it states that you're not allowed to store items in the common areas, or that for parking, it's only for a vehicle. It's not for the storage of personal property. So by taking a look at your rental agreement, you might be able to demand that the tenant comply. If not, that could be grounds for eviction. Anyway, thank you very much. We are moving on to Nancy P. Nancy
Can you
P.
hear me?
I can.
Yes. Hi, Dennis. I have a home and I rent a guest house for like approximately 5-6 years now. And all of a sudden, the son grew up already 18 or 19 years old, moved in.
What do you mean moved in? Wasn't he living there before?
No. No, the son actually is a husband and wife, but they got divorced. And the son is living with the wife in another property. And all of a sudden, the son moved into the guest house with the father.
Okay,
And
now when you rented the guest house to the father, was the son living there?
when he was a little child,
What city?
Glendora
Glendora?
is
And
incorporated with only county of Los Angeles, not city. It's an
okay,
incorporated.
so if it's unincorporated area
No,
of Glen,
incorporated.
oh, so it is the city of Glendora.
Yes,
Okay, you might be able to, on the rental agreement, does it list the child as a proper occupant on the rental agreement?
I have to check on that because
I would check on that. It's a tough call, especially when the child moved in with the father and the mother, then the child and the mother moved, and now he's coming back as an adult. You might have a case there. I'd really want to take a look at the rental agreement on that one. So what you should do is call our office so I can take a look at it.
Okay, and then the second question on the balcony, that one time you're talking about a balcony also have to inspect it by January 2026. Also the stairway. I have, my building is in city of Santa Monica. Is that also included for need to have inspection?
Balcony and stairway inspections are a state law, so it applies to every city and location in the state of California. Anyway, thank you very much. We are moving on to, I didn't pronounce this person's name right the last time, so let's see if I can do it this time. Mawa, are you there? Mawa Yi, I ask you to unmute yourself.
Yes.
Did it get closer this time?
Miwa.
Okay.
Was close this time.
Closer.
Yes. So this question is for my client. She has a house under a company name, and the lease agreement is also under company name. And the 60-day notice is also her company name. But 3 months ago, she changed the title of the house from her company name to her personal name. So when we serve UD 100, the plaintiff is going to be her company name or her personal name?
Well, first of all, did she do a formal change of ownership when the company name switched to an individual name?
No, I don't think so.
Okay, and when the tenant pays their rent, do they still pay it when they work to the company name and not to the individual?
Under company name, yes, they still pay.
So
Yes.
I would put that the plaintiff would be the company. I wouldn't change
Company
anything.
name. Okay, got it. The question is, a 60-day notice is for the correction of the city violation. So the tenants, can they use habitability as their defense?
I'm not sure I'm understanding the reason for the eviction. Is the reason for the eviction that this is not a legal unit?
That's correct.
Okay, then of course the tenant can't. You're not evicted. Habitability is only a defense when you're trying to seek rent. You're not trying to seek rent. You're saying
No.
that, hey, the city is telling me this is an illegal unit.
That's right.
You've got to go. I've got to pay you relocation under the
Mhm.
law.
Yes.
So the tenant can't claim uninhabitable. We're the
That's
first
right.
ones to agree it is uninhabitable
Yes.
because
Yeah.
it's an illegal unit.
Okay.
Anyway, thank you very much. We're moving on to Eric Chavez, trying to get through these calls today.
Hey, Dennis. So this property, RSO, City of Los Angeles. I think you've already answered this question, but so I have a tenant who, many these tenants are starting to become like paralegals, but I served a change of term, 60-day notice to charge an additional administrative fee, and they threw SB 611. Can you quickly elaborate on SB 611? Because I went through it and it just pretty much just said I just lost more
Well,
rights.
before I figure out what SB 611 is, you're not allowed to increase this is RSO property, so you're not allowed to do any kind of a rent increase. What is that code section? Because I don't know it by that number.
You know what? I have to look it up. I just know they sent me the actual code. I went through it. Something that just passed this year in 2025.
I know they require now that landlords supply refrigerator and stoves.
That's
but
gonna be the new one. Yeah,
That's
but
the new one, but I'm not sure what that
okay.
SB 661 is. Anyway, thank you very much, Eric. Moving on to Brent Enright. How are you, sir? Mr. Brent Enright, I'll ask you to unmute yourself. Okay, we will move on.
I'm here. I'm here.
We got you.
Right. Yeah. Do I click the little camera here for?
Yeah, click the camera. We get to see what you look like.
Do I pin here? Is that?
You just have to click on it. It should be in your bottom toolbar there.
Oh boy. Oh, I see down here. Sorry.
Usually
Yeah,
bottom
video, right?
left. There you go. Well, I don't think your camera's on though. Do you have a camera?
Oh,
you do
yes,
have a
I
camera,
do.
but it's not facing you.
It's not on. So can I just give it to you verbally?
Of course, sir. We don't have to see what you look like. What's your question?
I met you in the parking lot last Thursday at the Ag Lot.
Okay.
And you did a great presentation. And in your little package, or in your package, it's all important, but is this notice that I can't seem to find anywhere on LAHD. I think this is an older one, but correct me if I'm wrong. I think it's still required. The Los Angeles Rent Stabilization, parentheses, RSO, ALMC chapter XV, if you will.
I think that's just that it's a notice that this property is subject to the rent stabilization ordinance. Is that the one well, you wouldn't, normally they're in red. No, but that one's on my website, by the way.
So I can get it there?
Yeah, you can get it right on my website.
Yeah, okay.
And if you have RSO properties, you need to have posted on your property 3 different notices for the city of Los Angeles. One is the right to counsel. You have to have the tenant protection notice, and you also have to have the notice that says notice this property is subject to RSO.
Yeah.
All of those 3 forms need to be posted. If your property is in the city of Los Angeles and it's not subject to RSO, then you need 2 of those forms. You just don't post the one for RSO.
No, these are older. Our grandfather built them. So
yeah.
legacy
So that's
stuff.
that's definitely RSO.
I'll check on your website. I really appreciate your time. Thanks.
No problem. Thank you. And we're moving on to Alan Zayman. I'm going to ask you to unmute yourself.
Hi, Dennis. How you doing?
I am good, thank you.
Good, good. Thank you for everything that you do. I just have a general question. I was curious for tenants that are living in a condo, and the owner of that condo is interested in selling the condo. Is it possible to give the tenant a 60-day notice?
What city?
City, I think just Los Angeles, LA City, I believe.
Okay, in the city of Los Angeles, all residential units it's required to have good cause to evict. Good cause is not that I'm selling the property. So you don't have a basis of asking that tenant to move because you're selling. Now, if the new owner, if he sells it, the new owner could ask the tenant to move on the basis that he wants to move into his own unit. But the seller can't do that because he's not moving in, and that's not a ground to evict. Don't forget with condominiums, so you are allowed to raise the rent to market level. So that might be an incentive for the tenant to move.
I see. Okay, so basically, if once the new owner purchases the condo, it's possible for them to somehow get them out.
Right. The only exception to that, which is insane, would be if the tenant who's in possession of the premises is over the age of 62 and has lived there for 10 years or longer, you can't even ask that tenant to move in because you want to move into your own unit. So,
Right.
but if it's not that scenario, then you're fine in terms of that the new owner can do that. But the problem is, from a broker's standpoint, as you know, that who the hell wants to buy a property when there's a tenant in possession? And now, after I buy the property, now I got to deal with serving proper notices and paying relocation. So it's just a turnoff. So the city is just making it impossible to sell your own condominium or townhouse, or for that matter, house.
Makes sense. Yes. Yeah. Good old LA. What can we do?
Well, we can get rid of these people. Anyway, thank you very much. Bruce Rado, I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello.
Quick question. I just received an ESA notice from one of my tenants. And I think I know the answer to this already. It's a psych nurse practitioner that the person is seeing. I know that probably doesn't make any difference, does it, in terms of the provider?
It's any medical professional, somebody who is licensed in the state of California. So she has to have her license number on that ESA letter. And of course, that the patient, your tenant, had to treat with that person 30 days before issuing that ESA letter.
Okay. And then just one quick question. I have very nice wood floors in the unit. Can I send a text or an email to the tenant, because they're getting a cat, about cat urine and wood, in terms of saying, just be careful if you would?
Right.
respect to the property.
If you're going to get this cat and if it's going to cause damage to my floors, you're going to be responsible. It's just putting you on notice. Sure. I think that's very good. We're going to move on to Nikki. How are you?
Hi, I have two questions. The first is from the tenant side. The second is from the landlord side, which my dad is going to ask. So I'm going to ask the first question myself. I recently left my apartment unit in October, and I rented it on a month-to-month basis from the previous tenant on a change of occupancy form. And my question is now regarding the security deposit, because the landlord wants to charge out of my security deposit, even though she never came and walked once the tenant moved out. Instead, the landlord's policy is that because the previous tenant replaced me with them, I was responsible for taking photos and inspecting the place, and I paid the security deposit actually to the tenant who moved out. So the landlord is holding the security deposit because it was a 2-bed, 2-bath, and she refuses to return the security deposit unless both tenants move out. So her policy is once one tenant moves out, they find a replacement to pay them the security deposit, and through that, the incoming tenant will deduct anything that they find is wrong.
Did the landlord sign something where between you and the new tenant coming in that the tenancy was going to be changed?
Yeah, so we signed a change of occupancy form.
Okay, and the landlord signed that too.
Yes.
Okay, so I think the landlord is on the shy side of this argument. He should have put in there that specifically that I'm not giving you back your security deposit, then you're going to have to get that from the third person. But so since he's already excused your absence by signing this agreement, which basically switches tenants, then he's duty bound to give you back your security deposit or that portion of it.
Yeah, because now they want to charge for a cleaning fee and also say there's a couple of things I left in there which weren't mine, were the previous tenants, but I didn't know that, they were the previous tenants, or if the landlord left in there. There was no record of it.
A landlord can charge for cleaning. As to the other item, the landlord would have to prove that you're responsible for that. So what's your landlord question?
Hello, Dennis. How are you?
This is still Nikki I'm talking to.
Yeah, sorry, I'm just giving it over to my dad because he can.
Oh, I'm
speak to that
sorry.
more, sir.
Yeah.
I didn't realize we had twofers there.
Yeah, no, my daughter is a tenant and I'm the landlord.
Well, I'd rather be the landlord than the tenant. How's that?
Okay, that's the regarding a water leak by the tenant. And this is located in a house, single family house in Calabasas Hills, which is basically is in incorporated area of the Calabasas. And we do annual inspection. And this time I set up the time with the tenant for month of October 10, 11 to inspect the house, which basically I did. And during this inspection, I noticed that there was a remarkable water damage to the flooring of the kitchen, of our dining room, and in a family room. I asked the tenant what happened. She denied first and then said, I noticed that there is something here, and I asked my handyman to come out to clean up. And I said, what then happened? Back to June. It means that June, July, August, September, 4 months, she did not report it to me for the water leak.
Yeah, let me slow you down here to move this along. The issue is, how did that water leak occur? Did it from a busted pipe? How did the water get on the floor?
Yes, there was a refrigerator in the kitchen, which refrigerator was responsible for ice making. Back of the refrigerator was connected to a faucet,
Whose refrigerator?
the tenant.
And so did it leak from the appliance, from the refrigerator, or did the water line to the refrigerator break and that's why it leaked?
I just exactly don't know, but I think that it was from the faucet connected to the refrigerator.
Okay, so generally speaking, if the tenant didn't do anything, what you're saying is that the tenant is responsible to tell you so that the leak wouldn't have continued to happen. I don't usually see it that way, that if it was the tenant's refrigerator that caused the problem, then it's the responsibility of the tenant. But because there's a water leak that wasn't your tenant's fault, because the tenant, quote, didn't report it, I don't think you can hold them liable. However, in my rental agreement, I have a specific term that says if there's some sort of a water leak, you have an obligation to inform me. And if you don't, then you're responsible for any excess damage that occurred as your failure to report. But that's it's kind of a close call on that one. Anyway, thank you very much. We are moving on to, could it be? Is he ready? Harold Rhodes, how are you?
Is it working?
It is. I think it is. I'm going to unmute you again. Try again.
All right, I should be in. Hello?
You got it.
Hey, Dennis, real quick, just dovetailing on what that guy was saying. If the tenant was responsible and it's according to your agreement, what is your recourse? Can you use that as a reason to evict if they don't do anything? As far
Yes, what I would do is I would repair the damage. I would present the tenant with the invoice for that amount. And if the tenant failed to pay, I then would serve on the tenant a notice to perform or quit, giving him 3 days to pay the invoice. And if he doesn't, then you could go forward with an eviction. Also, of course, you'd be able to deduct that from the security deposit if you wanted to go a different route.
Okay, so here's the question. I'm just wondering if you've ever done a class on getting a tenant to get the insurance for the place, because there's like 5 or 6 questions about it that I'd like to know about. And if you haven't done one, I'll send you an email with some questions I have about it. It's like 5 to 10 questions.
Feel free. I mean, the reality is that under California law, you can't evict a tenant for failing to get renter's insurance. However, the reason why you want to put it into your rental agreement and why it's in mine is that if the tenant tries to reach out and sue you for damage to his personal property through no fault of the tenant's, or if the tenant has to relocate through no fault of the tenant because there was a major water leak, then the contract says that he has to seek reimbursement by his own insurance policy. So if he doesn't have it, that's not your problem. So
Well,
that's
I'm
why
saying
I
is
always recommend that being in there.
right. What I'm saying is before the tenant moves in, set it up like this is the amount of insurance you have to have, the coverage, a way to make sure that he's paying the insurance, that kind of stuff.
Yeah, again, but you could do it on the way in, say, I need to see this insurance policy before, but if he cancels the insurance policy, then there's really no way to enforce it under California law. Anyway, thank you very much, Harold. Moving on to Juan. How are you?
I am doing good. I wanted to ask you a question. I have the rental agreement for the the one that you wrote for the AOA people, and in that agreement it says that there is a percentage that if they're late that they have to pay. So now that's not done or anything like that.
Yeah,
How's that?
I don't believe that provision is still in their lease. Everybody's kind of changed their leases based on these laws. So I don't like putting a percentage in because again, it's hard to justify that as a liquidated damage because again, 5% of 2,000, if that's what the rent is, versus 5% of 5,000, and those two figures are obviously a big difference. And yet, how do you justify that when you're really doing the same things, calling the client, going to the bank, having more bookkeeping detail?
So in this case, would I be able to at least charge the $50 or I won't be able to charge anything like that?
I mean, you can try to charge it, but I wouldn't try to enforce it by let's say, doing an eviction.
Okay, and then just one more thing. I have my ADU under, I live in Whittier. It's not rent control, but I have it under an LLC. And they make out the check of the LLC. Like if I ever have to evict somebody, how would I do? Would I put the name under the LLC name?
Yeah, if the rental agreement is the landlord constitutes an LLC and the tenants pay their rent checks, then the lawsuit has to be filed in that company name. Now, what a lot of people don't understand is I don't recommend this no matter what, but you can't represent yourself if there is an entity that owns the building, like a limited liability company, an LLC, or a corporation.
Okay. All right, then
And thank you. Moving on. We're going to see if we can get through everybody today. Albert, how are you?
Great, Dennis, and thank you for the great show. Two questions. If somebody constructs a brand new ADU, do they have to be ADA compliant?
I'm not a builder, but I'm sure whichever contractor you use would comply with all the building laws, which would probably be ADU compliant.
I just heard that the new ADUs have to be American Disability Act compliant.
Yeah, I guess you're going to need to put up some ramps or whatever, but I'm not really sure of the laws. I don't do building law, but again, if you're hiring a licensed contractor to get this as a permitted legal unit, they're going to know what the rules are.
And the other question is that in the RSO units, just sometime I see people coming in the unit, I don't even know that. Can I basically ask for the information and a copy of their valid
Well,
ID?
you can certainly ask, but they don't have to give it to you. And the fact that people are coming into the unit, you know what that means? Maybe the guy's having a Bible study class. You don't know, and you're not really allowed to sit there and start making it like a nuisance behavior on your part. So I mean, but if you see the same person coming and going morning, evening, you see their car parked, well, then that's not a guest, and that would be somebody who's actually occupying the property. Anyway, thank you very much. Moving on to Hortensia. I'm going to ask you to unmute yourself. Hortensia. You're good now, darling. Go ahead. No, you just unmuted yourself. Try hitting the microphone one more time.
Can you hear me now?
I can.
I have a question, two questions, but at least one get answered. If I have a two storage ADU or apartments, and I have a stairs that doesn't go attached. It's attached to the wall, but it's not inside. It's outside. Do I need to get an inspection or certificate for that?
Yeah, exterior staircases that are not inside the four corners of the building need to get inspected, and that has to be done by January 1st of 2026.
Okay, but if I have a RSO building, but the stairs are it's a fourplex and the stairs is between the two units in each side.
Yeah, if
So
if the staircase is floating by itself, I guess that's a better way to say it, then you have to comply. And this has nothing to do with a specific locale, because this is a state law. So you have to comply with that and do it by January 1st. Thank you very much. Moving on to Triumphi. Ask you to unmute yourself. Try again to unmute.
All right, there we go. I'm a little bit quick on the trigger. Thanks again for the great segments as always. Last week you helped me out with a situation, duplex, owner occupied. I want to move my mother in the other unit, right? So I served them the 60-day notice, saying they, to move out and,
Yeah, what city, please?
I'm sorry, Ridgecrest, California, Kern County.
Kern County. Okay, so I don't believe there's any rent control there. And you live in the duplex?
Yes, I live in the
Okay,
duplex.
so if that's the case, you're exempt from statewide rent control since you moved in prior to that tenant moving in.
No.
So just serve a standard 60-day notice and say goodbye.
I didn't move in prior to the tenant.
Yeah.
The tenant been in before me.
Oh, I'm sorry.
Yeah, it's
the
okay.
tenant lived there prior to you?
Yep. Bought the place about 2 years ago. The tenant's been in for
okay,
over
so then
10
you
years.
are under statewide rent control, so you have to have special language in that 60-day notice, and you have to offer the tenant 1 month's rent as relocation.
And I did that, right? So this is where I'm at now. I did that. They immediately got in contact with me and said, well, hey, I really want to stay in this place. Can I pay you more rent? Because right now they're way below market rent. But now they're saying their words, they emailed me and said, hey, I want to live in your place. I want to pay market rent pretty much. What do I don't want to get in trouble because it's well above.
So that would be like two people writing a contract where it is legal to commit a murder.
Right.
And that contract wouldn't be worth much. And the same thing is true. You can't, even if the tenant agrees, hey, I know that that you can't raise my rent, but I'm agreeing to it. If you take that rent, it's like a ticking time bomb. The guy can come back at you, years later, ask for all of his rent back, and then not only ask for all of his rent back, sue you for attorney's fees as well.
Would it be the same lines as if we go through with the 60-day notice, I put it back on the market like now, and then they reapply to it? Would that
No,
okay.
Because
that's the same difference, right?
I went to law school over 50 years ago, and I remember what one professor once told me, and that is, he said, the law is not an ass. And what he meant through that, what he meant by that is you go through form to the substance. And the fact that he moves out for a day and then comes back, no, that's not going to fly.
Gotcha. All right. Thank you.
Anyway, thank you. I see a good friend of mine, Mark, who's in the Zoom meeting room. Hi, Mark. Moving on to David. How are you?
Yes. Hi, Ed. How are you?
I'm good.
Quick question. You clearly mentioned the problem with charging late fees for tenants residential. Is that also going to be true for commercial? And if it is okay to do that to commercial tenants, how high can it go? Please
there's no limitation, but in commercial, you're not stuck with these rules. These rules were in residential cases. But again, you can't make an obscene amount. Most commercial leases say 10% that I've seen on the standard industrial lease. So I would limit it to 10% if the rent is not paid on time.
In someone's lease, it says $100 per day. That is not a good one, no?
That would be terrible. You couldn't enforce that.
Okay, thank you, Dennis.
Thank you. That was a good question. Tom's iPhone. I'm going to ask you to unmute yourself.
Hi, Dennis.
Hello.
Thank you so much for everything you do. Regarding the inspection on the staircases and the balconies by the end of the year, how does the contractor send a certification or inspection report to the state, or how is it monitored?
Good question. And the answer is no, he doesn't. He gives you the certification. You do nothing with it except to put it in a drawer. If you're going to sell the property, you're going to need to include that with your escrow. The only time you need to send it to the local building and safety for that area is if it doesn't pass inspection. If it doesn't pass inspection, then you've got to send it to building and safety. They're going to come out there and they're going to make sure that whatever you're doing, you're correcting it.
Okay. One other, based on what you had said, if the inspection is not done and the property is sold, let's say a year from now, an inspection at that point, would a seller be in trouble for not doing it?
Well, I
since-
mean, the seller's going to be forced to have it inspected at that point to comply with the law.
But
See,
they're
the
not-
problem would come up. I mean, no one's coming after you. The problem comes up is what happens if that staircase falls down or the balcony falls down and you never got it inspected. Now you're looking at a lawsuit that you wouldn't believe. So,
Yeah. Okay. All right. Thank you.
and thank you. And I would normally end it here, but I'm going to say hello to Mark. I'm going to ask you to unmute yourself, Mark.
Thanks, Dennis. Appreciate that. Quick one on the appliance law. Is there anything in that law that prevents us from charging extra for providing appliances to choose between like an appliance package or they supply their own? Is that okay with the law?
That's an interesting question. I don't think anybody's thought of that one because the law hasn't even come into existence. So the issue is this is what you're saying. This is the standard refrigerator and stove that I supply. However, if you want to, are paying it on a monthly basis more? Or just a one-time fee, you'll pay an extra $400 for this?
I think if they supply their own, no charge, but if they want new appliances put in, I would charge them 75 or 100 a month. Would that
Yeah,
work?
I don't think you could do that because then you're supposed to supply it. It's part of what is required to be in that. So if what I would do is just set the rent, and that's what I'm telling people now. Now that you might be forced to put in a stove and a refrigerator, then I would adjust my rent so that it's higher for on just what the rent will be, so that anybody coming into the premises, that's what the rent's going to be, and you've already built into that rent the appliance charge. Anyway, nice talking with you, Mark. I'm going to end it here. It's been another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. We do have a website, evict123.com. Again, for you guys listening to me, if you got a question during the week, you can always call my office, which is again 1-800-77-EVICT. You're going to get an attorney on the phone who's going to answer your question in a short fashion, kind of like what I'm doing here. But we will do that for you. And you guys in YouTube land, hey, hit that like button and subscribe to my channel. And thank you very much. Have a great weekend.